Today we're just going to talk about COVID and what it is doing with the rental market. There is so much information out there, and every jurisdiction has something a little bit different. Do my tenants have to show documentation? How long do they have? What kind of notice do I have to give? So I'm going to try to touch on most of the, I'm going to touch on the state order, the local orders, and what the court system has just done recently. So the state order was modified on March 27th. It pertains to residential only through May 31st. This one does require the tenant to give notification to the landlord within 7 days after the rent is due in writing why they have to delay the payment of rent. The types of reasons why they can defer payment is obviously unavailable to work because they're sick or been hospitalized or caring for a family member, if there's a layoff, loss of hours, or other income reduction, or even having to miss work because their child care is closed or schools are closed. So now that's kind of a state blanket order. Now, the county and the cities have all gone and done something different. So the County of Los Angeles Board of Supervisors, their order is for unincorporated county. It's from March 4th to May 31st. Now, I'm giving this presentation today, but on Tuesday, this information might change because on Tuesday, the Board of Supervisors are meeting again to expand the repayment time and lessen the documentation requirements. So as of today, this information is accurate. As of Tuesday next week, it may not. The unincorporated county is for residential and commercial. Non-payment of rent, a landlord, they can defer the payment of rent if they demonstrate an ability to pay rent. A client of mine sent a newspaper article by one of the tenant attorneys that says that they don't have to provide documentation. Well, that's not true in all of the ordinances. My legal brain says that demonstrates means that they have to show in writing some way that they have the inability to pay rent, whether that's giving a letter from their employer telling them that their hours have been reduced or they've been laid off. Tenants or landlords can't charge late fees during this time. And the tenant does have to give notice of that inability. Policing it, you know, I don't think it's really going to matter whether or not the tenant actually gave notice prior to not paying your rent. They're just not going to pay the rent, and then the landlord's going to have to reach out to them and say what's going on, and they're just going to tell them that they're not going to pay rent for whatever reason. This applies for any notices and evictions that were started after March 4th. So if something happened after March 4th, everything's to a halt, they can't do it. Under the unincorporated county, as of today, they'll have 6 months from the end of the executive order, which is May 31st, to pay the rent. Like I said, the meeting on Tuesday, what's on the agenda is that's going to be extended 12 months. And it also extends to no fault evictions, which means it's not a non-payment of rent. So if there's one of those reasons under 1482 that you want to evict, like you're removing it from the rental market, you are doing construction, and you're doing a 60-day notice to quit, those are part of this moratorium that you can't evict for that reason as well. So then the city of Los Angeles has their own rules, and that applies to residential and commercial. The language used in that statute or that ordinance is they have to show an inability to pay rent. So again, my argument is that this means that they have to give some type of documentation to show of their reason of the inability to pay rent. I've had clients call and say, well, some of my tenants are, retired and get retirement. Well, then they need to pay the rent because they don't have a reason why they can't pay rent, because they're not having a reduction in income. Under the City of Los Angeles, the residential repayment has been extended up to 12 months. Commercial is 3 months, and I think that might be extended, but they just recently extended the residential to 12 months after the order is lifted. And the under the RSO, so Rent Stabilization Ordinance in the City of Los Angeles, or in any of the Rent Stabilization Ordinance properties, the landlord's also required to give notice within 30 days of the ordinance date to their tenants of their rights. That's not blanket throughout all of the jurisdictions. I'll talk about one of the other jurisdictions that's requiring some notice. As a general practice, if you have a client that has property, it wouldn't hurt. There are free forms on my Facebook page from the Apartment Owners Association of notices to the tenants that kind of lays out what the rights are, what they have to do, what they don't have to do. But it's not mandatory except in the City of Los Angeles and I believe Santa Monica. Like I said, in the Rent Stabilization Ordinance, you must provide notice to the renters within 30 days of the ordinance date of their rights and under these moratoriums. And also just recently, they did a rent increase freeze. So landlords now in Rent Stabilization Ordinance properties can't do any rent increases during this time. So drawing it down to some of the more local ordinances, City of Hermosa Beach came out with one that relates to both residential and commercial. For residential, the pertinent word is demonstrate the inability to pay rent, which again to me means that they have to show that inability. They have to give documentation of something of the reason why it's COVID related. In Hermosa Beach, it explicitly says you can't serve a 3-day notice to a tenant for reasons of, once they show that the landlord has not paid, or the tenant hasn't paid rent. And I think there's some questions in chat. If you could do your questions in the Q&A, that'll help me be able to track them more. So if you put something in chat, if you could put it in the Q&A so that Nikki and I can see it, because I don't have the chat window up. Under Hermosa Beach, it's a repayment within 6 months, and you can't start the eviction within that 6-month repayment plan. I was just talking to a potential client now, and the question came up, well, what if they don't start paying the rent that comes due after the expiration of the emergency orders? So say these emergency orders are all lifted on May 31st, which is what we hope and can continue to hope that it doesn't extend past May 31st, is technically then they have to pay June rent first, pay the rent June 1st. It's likely that you won't get June 1st rent because they're not working the month of May. So anticipate that it won't be until July 1st that rent would start coming in. So what if rent isn't paid on July 1st? Oh, yeah. Sorry. If rent isn't paid on July 1st and they don't start paying the repayment, what can a landlord do? Hopefully they'll start to go through this process because the deferment's over. They need to pay the rent. So in my mind, the landlord should be able to go ahead and issue a 3-day notice for July's rent or say August's rent when they start not paying. So I have a question. What does a renter have to show to demonstrate the inability to pay? Yeah, so a letter from their employer. It doesn't matter who writes it. I guess it just needs to be signed, but I think that it'd be more official and more believable if it's something directly on the employer's letterhead signed by the letterhead or by the employer. The biggest rub I think that people are having a problem with is landlords are asking for bank statements. I don't think that really is the way to do it yet, because obviously we're just in that first bunch of time period that would show a difference in somebody's bank account from last month to this month. Maybe next month there'll be more. I've read that some of the jurisdictions are saying that pay stubs, showing a pay stub from 2 weeks ago and then showing one from this pay period that shows, you know, a half reduction. Your pink slip, somebody's, you know, let go, so you just show them your pink slip. For the most part, if you know your clients know their tenants are in the gym business or hairdressers or event planners, you're going to kind of just assume that they're not going to be able to pay rent. You can still ask for the documentation, but their businesses are closed. If you know what your tenants do, I'm telling all my clients, be patient, be understanding. You don't want you to be the one that's in the news by being the jerk that is, you know, demanding payment of rent and demanding even more documents when it's clear that they are a hairdresser and are not able to see their clients. How do you know their documentation is legit? Well, I guess you would just have to take a look at it. And like I said, if it's a letter from their employer on their employer's letterhead, or if their bank statements or pink slips, you just have to, I guess, look at them and see and make that determination. So the next question was, so the emergency order has been lifted, rent and back rent is due. Do you send a modification with additional rent due? So right now, what I'm advising my clients is, if you have a tenant that can't pay rent, reach out to them and try to work out a payment plan now. It is not mandatory. They have, whether it's the 6 months or the 12 months, to repay it, and they can repay it in any way they want to within that period of time. But what I'm suggesting to my clients is reach out and say, okay, we understand that you can't pay April, May, and June rent. Just go that extra month. If it listed on May 31st, they're not going to be able to pay June 1st. So you're going to owe X amount of dollars for that rent. I would divide it in the 6 months or the 12 months, depending on what the repayment plan is in that jurisdiction for that property, and say, okay, so if your rent is $2,000, you're going to have to owe another $500 a month over the 6 months. So for every month after starting July 1st, you need to pay, you know, $6,000 or $600, $500, or whatever the dollar amount is. So if your rent's $1,000, you're adding $500. You know, for the next 6 months, pay $1,500. I wish rents were that cheap, but I'm just trying to give examples. It's not a modification. It would just be a repayment plan. I would always try to say, get that in writing, but it's not mandatory for the tenants to agree to that. They just have to pay it back. What about self-employed freelance artists, actors, and entertainment? So I think that that just goes to understanding and being understanding that they might not have that documentation. Depending on how much property your clients own, like I own a 4-unit building. I'm just new to it, so I don't know my tenants yet. But if I only had that many units and I knew that they were all in some type of industry like that and they came to me, I'm just going to try to work something out and be understanding, because they probably can't demonstrate that with actual documents if they're the ones. I guess that's where bank statements could become relevant, if that's the only way to show that they have a reduction of what's coming in. Once the tenant is evicted, how do you collect rent? Usually you don't. That's in any case, whether it's COVID related or not. Some of my clients are steadfast and will keep trying. They send it to collection agencies. Judgments are good for 10 years. They can be renewed for another 10 years. But if they're not paying rent, good luck. But you can, once you have a judgment, you can try to garnish bank accounts. You can try to garnish paychecks if you have that information. That's why I'm saying, if you can work out a payment plan with your tenants to get some kind of money in your pocket while this is happening, that's better, because in the long run, if they don't get caught up and you have to evict them, you're probably not going to see the rent. The next question was, just because they lost their job, that's good enough, even if their bank accounts show that they can pay. So again, I think that that's going to be property managers and landowner or tenant landlords' call. We're going to talk about it a little later, but the courts aren't taking any evictions whatsoever for any reason whatsoever. So if your tenants are just not going to pay rent, even if they can pay rent, there's nothing you'll be able to do about it right now anyway. You can just try to have a discussion with them. People are out there, even the tenant attorneys are saying, if you can pay your rent, pay your rent. This shouldn't be abused, but it will be abused. I had clients say, well, half of my tenants are retired and they're not having a reduction to pay. Well, then they have to pay the rent. But if they don't, unfortunately, there's not anything we're going to be able to do about it. You could serve a 3-day notice for that non-payment of rent if you're allowed to in your jurisdiction. City of Hermosa, you can't. But you're not going to be able to file anything, and I'll talk about that a little bit later. And then, so the next question I have is, what if they were fired from their job not related to COVID, but they are using COVID as the reason? Again, judgment call, I guess. If it's not COVID related, they're supposed to be paying their rent. It said tenants are going to abuse this. They're going to take this as their opportunity to get a few months rent, but the problem is that they're going to have to repay it. As soon as this was lifted and they have never demonstrated to the landlord that it was a COVID related issue, then the repayment plan doesn't count. And I would advise my client, if they never showed you or told you that this was COVID related and you're pretty certain it's not, then you do the 3-day notice and you start the eviction. And then they would have the burden on them at the trial to show that it was COVID related. So I would only suggest that if you're pretty positive that there wasn't a relation between the two. Because the repayment plan is really only for them that demonstrate the inability to pay due to the reduction of work or income. And I'm going to guess HB is Hermosa Beach, the only city within LA County that has a 6-month repayment rather than 12. No, so most of them are all 6 months. Under the state order, it is 6 months. Then it is 12 months within the city of Los Angeles. And then possibly after Tuesday, it might be the entire county. So as of right now, under the state order and the county order, it's 6 months. But as of Tuesday, the whole county of LA might be extended. I am not sure. I didn't look into like Orange County or Riverside County, that they might be different. But right now it is, under the state, it's 6 months. So if there isn't an ordinance that specifically says otherwise, it's going to be 6 months. Back to the city of Hermosa Beach, commercial, it applies as well. And again, the tenant must demonstrate the business is subject to orders or is otherwise closed to prevent or reduce the spread, and the tenant demonstrates financial impact. So if your commercial property is a gym and they're closed because of this, then, you know, they're going to be financially impacted. So the commercial are really specific about it having to be subject to orders that have limited their ability to have, for instance, restaurants. They can't have dine-in, so that's probably reducing their income substantially because they're only doing takeout, and it's very limited to how many clients are coming instead of dining in. So those types of commercial properties, bars are closed. They're going to be falling under this ordinance where you can't evict them during this moratorium. So the next question is, when does the clock start for the repayment period? Under the state order, it is May 31st. Let's just go back and double check. So under the state order, it is residential through May 31st. For the county of Los Angeles, unincorporated county, it is May 31st. The city and the other ones I don't think have actually specified. Actually, I think the city of LA said that it's at the pulling of the executive order, and that one is scheduled to be pulled on April 19th. But my guess is everything's going to be extended to May 31st. So that's kind of what I'm telling my clients, is to look at it through May 31st. If the county extends to 12 months, but Hermosa still says 6 months, the most restrictive applies. So if you have the state order and then a city has something more restrictive, you go by the city. Or if the city is more restrictive than the state, you go with the city. So whatever is the most restrictive, which would be the more time period. So once the county says 12, then every city in the county would be 12. The city of Palos Verdes, what is the current stance for renters? I think that they're going to fall under the state order, because I didn't see that they had a specific city ordinance, but I didn't check in the last couple of days. So I'm just going to say that it's a blanket moratorium under the state order, or the county if they make those changes on Tuesday. The next one's a good question. The moratorium is against evictions. Isn't there a manner of legal action available simply to sue for financial damages of breach of contract, non-payment of rent? Typically in residential, you can't do that at all. The only way you can send them to collections is if after somebody has moved out, and you can establish the exact book record of what the amount of rent is due, then you can take that to collections without even taking them to court. Commercial tenants, usually upon breach of the contract is when they have vacated the property and you sue for the remaining term of the lease. I don't really know of civil actions that you can do while these tenants are still within the property. Yeah, with these months of no rent, they'll simply not pay rent and await eviction, which will be completely backed up in the courts anyway. Yes, as we'll go into that a little bit more later, is the courts are not accepting any. If you have clients that are concerned about when they're going to be able to do this, the earliest, if it's not COVID related, would probably be sometime in September or October. So everybody's just going to have to be patient. Hopefully, talking to some landlord owners, most people are paying the rent right now. There's a small percentage that aren't, but that is my guess, because we're not in a full month of effect of the cuts, because we started this, in the middle of March. I'm going to expect that more and more people will say that they can't pay rent come May 1st than they did April 1st. I haven't seen anything on Torrance, but again, I haven't looked in a couple of days. And yes, I will provide, when this is done so that I can get back into my screen, the best source that I've been finding is the Apartment Owners Association of California has a free link that has a bunch of forms, and it also has all of the pertinent counties or cities that have ordinances, and you can click on those links to go to the text. Is Manhattan Beach the same as Hermosa? Again, I haven't seen one for Hermosa yet, so I'm not sure if that's the case. My guess is if Hermosa Beach is doing something, the other cities will follow. But as Tuesday, it all might be moot, because if the County Board of Supervisors says it's the whole county, that's what's going to apply. And my guess is that they're going to be the most restrictive, because they're going to have the 12-month repayment plan, and they're going to have the ones that have less of a document-heavy request to demonstrate that inability to pay rent. Long Beach currently has an ordinance. It's both residential and commercial for non-payment of rent. That is also a notification requirement. The tenant must, before the expiration of the 3-day notice, notify the owner that they can't pay the rent. So in Long Beach, they're anticipating that these landlords are serving 3-day notices, and then they're telling the tenant that they have to provide the documents. The 3-day notices in Long Beach require specific COVID-19 language that gives them the right and tells them that they have to give the notice. So just be careful if you have clients to just double check the ordinances, because some, like Hermosa says, you can't serve a 3-day. Long Beach is saying that you can. The county ordinance or the state ordinance doesn't give any guidance on those issues. What if the eviction process order began? I'm going to talk about that one in a minute. That's the last thing, is what the state court's doing, so I'll get back to that one. If a lease expires during the moratorium, can you decide not to renew the lease and ask the tenant to leave? There's nothing in any of the ordinances that prohibit that, but I think doing so is going to be against the spirit of what these ordinances are, which is putting somebody out of a residential property. These were all put in place to make sure that people had a place to be and not affected by being, say, homeless if they couldn't find some place to go because the rental market is down or people aren't doing things. So I think that that would be on a case-by-case basis, depending on what the circumstances are. I would say that if you have one that's going to expire, you give your required notice of non-renewal that this lease is not going to renew, but work with the tenant and have it in writing that due to COVID-19, your lease has expired, but we're allowing you to stay until a certain date with the agreement that you're going to pay rent, and this does not create a new landlord tenancy, month-to-month tenancy. If you have something specific like that, I don't see why you wouldn't have a problem with it. I just would do that on a case-by-case basis. Inglewood has its own ordinance. It's residential and commercial. The financial hardship, it has to be linked to COVID, and it's in effect for 60 days after the expiration of the order, which means that they have an extra 60 days, from my understanding, of a rent forbearance instead of it just being lifted right away. And under Inglewood right now, it is 6 months to pay, but again, if the county decides to go wider to 12 months, then that's going to change. Is it legal to force landlords to make tenants collateral-free loans? Loans, to make tenants free loans. I mean, I'm not sure on how that would benefit the landlord if you're looking at it that way. If a landlord wants to give a tenant a loan and then repay them back, that wouldn't make sense. But if they wanted to be nice and give them some kind of loan for food or whatever, I don't see why they couldn't do that. Just know that you might not get it back. And then the next question is, it's recorded? I think so. I think you'd have to ask Nikki, but I think she said it was recorded. Can landlords get mortgage forbearances? Yes, my understanding is most of the banks are doing some kind of relief, whether it's a forbearance of 3 months or tacking it back at the end of the loan. I've heard that some are, you might have a 3-month forbearance, but that all might come due at the end of that 3 months. So you have to understand that while you don't have to pay it these 3 months, on the 4th month, you might have a big balloon payment, or they're adding it to the end of the loan. Those are going to be lender specific. You should reach out to your lenders. What do we do if the lease expires in June and they owe for April and May? Can I still collect the past rent? Certainly. If they vacate in June and you don't have to do an unlawful detainer, an eviction case, then you would just send them to collections. I know a lot of my property management, you don't have to have a judgment for that. You just have to have them vacate, and there are certain collection agencies that specialize in rent rolls. So you would just do that and try to collect it that way. If you do an eviction action where they're supposed to move out and they don't move out and you file the action, then you would just add that as a part of your damages as the past due rent. What about tenants who want to break their lease because they lost their jobs? Okay, that's going to depend. I think that that's going to depend on the lease agreement. My gut is going to tell me that if any of these are litigated, and this has been a conversation amongst the attorneys recently, is if these matters are litigated, most likely the courts are going to find in favor of the person that wants out of the lease or out of the contract, if any kind of contract in general. Most contracts have what they have, the force majeure provision. They are the act of God or unforeseen circumstances that allows somebody out of the lease or out of a contract. So it's going to depend on your contract. And I think it's on a case-by-case basis. I think we just need to be understanding in this time. I'm a landlord. I understand the need. That was my biggest thing coming April 1st was like, were they going to pay the rent so that I could pay my mortgage? Because I rely on the rent to pay the mortgage. But these are times that are so uncertain, and you just don't, I don't know, I just don't want to be that jerk that's going to be looked at in that way of, you know, forcing things when somebody can't do something or can't perform under a certain contract. So I think I would take those on a case by case. Obligation to release them from their lease, it really depends on the contract. How do the new ordinance affect short-term monthly rentals? You know what, I didn't look into that. I think that there are specific rules about these short-term rentals that are separate from these. If you want to reach out to me via email and just remind me, I can look into that for you. I didn't look into short-term rentals for these. The local government is forcing me as a landlord to essentially make a collateral-free loan. Okay, so I understand what your question is now. Yeah, you know, I was in a call the other day, and there's probably going to be a lot of property right lawsuits because they are really limiting your rights as a property owner. But that's same with the ordinance they enacted January 1st. Enacted January 1st, where they're limiting what you can do to evict a tenant. Yes, whether that's legal or not, I think it's going to come to play to see how many people challenge the constitutionality of these. But right now, they're just trying to protect tenants from being put on the street during this time to, you know, one, the homeless population is probably going to hit pretty hard because they have no way to prevent the spread because they're all huddled together. So I get what you mean. Yeah, your tenants will probably never be able to pay the back rent. And it is really unfortunate. Like I said, I feel everybody's pain because I'm a landlord as well. Is there a resource like Apartment Owners Association, but for tenants? Probably. I know that there's several different types of tenant protection programs. I'm not familiar with them. I don't know the links, but I assume that there are some, and I'm sure all of the tenant protection attorneys out there will be happy to give some guidance. I can see them pop up on Facebook, you know, with all their information. If tenants are asking for clarity on a lot of this but can't afford an attorney, is there a trusted site? Or so that same question. Yes, I'm going to guess that there is. I can also, if one of you wants to email me after this, I can look it up because I know that there are Public Counsel is one, BASTA is one. They're attorneys, but I'm sure that they're going to have lots of resources on their pages to help these tenants. And if the tenants are really looking for counsel, those BASTA is supposed to be not profit, but I know that they do sometimes get paid. Short-term rentals, especially Airbnbs, do have their own rules and have not been sent to owners. Those laws are mandated state by state. I believe that's the case, but I think that there's also some new regulations, just emergency-wise, with these, with what they can and can't do right now. My guess is I think, well, I shouldn't say that. I don't know, because short-term rentals, I had our B&O place for a week and canceled it because of the not wanting to travel. Generally, just other cities that have enacted their own: Beverly Hills, Culver City is residential only. Glendale has rent increase freeze and applies to commercial tenants as well. Santa Monica on April 8th issued a supplemental order where they must provide notice to the tenants of their rights. Like I said, most of the jurisdictions and under the state and mandate, there's no requirement to notify your tenants of their rights, except Santa Monica and I believe Long Beach requires, and maybe Hermosa. And West Hollywood has an ordinance. And like I said, I will put the link on before we close out this to the apartment association. That apartmentowners.association.org could be it, but I just don't know it by heart. I just type it in and it comes up. But I'll put that link on there because it has a list of all of the ordinances. If tenant is not paying rent and is a landlord, rental income is dependent on the landlord to pay mortgages. What rights does the landlord have? Again, that's going to be lender specific. I don't know if the government is coming out with stimulus packages or benefits other than reaching out to your lender to find out what relief they give. The other day when I was looking, it looked like most banks are offering some type of relief. If you go to chase.com, they have a link for going to, information on what you can do and what you need to send in. Most of them are all just kind of a forbearance program. The court, I'm going to go into that next, is the courts have halted all evictions, but they've also halted all judicial foreclosures. The problem is anybody that has a mortgage is with a deed of trust, and that's not a judicial foreclosure, it's a non-judicial. So that's where you need to have your owners and your property owners reach out to their lenders and try to find out what the relief is. And finding out now instead of scrambling at the end when say 80% of your tenants paid the rent this month, like mine did, I was able to pay the mortgage with that, but next month I might not be in the same boat and I might need to figure something out. Try to figure it out now so that you know what to do when it happens, or if you can do something ahead of time without showing them, because I haven't looked into what the parameters are. I don't know if the banks are requiring you to show that your rent's not coming in or you have the inability to pay the mortgage. But the courts, as of about 3 days ago, have halted all evictions of any kind no matter what. I had a client send me a matter the other day, just as this was coming down, for non-payment of rent for January and February. It doesn't have to do with COVID, but I had to tell him, I'm sorry, you're going to have to sit in the queue. It is halting all evictions until 90 days after the state of emergency is lifted. So while all of those statutes are in play about what they can do and what they can't do, and the demonstration of the ability to pay rent, it really doesn't matter if they can or can't and they can't show it. It's just a matter of when can you go into the court to sue them to get them out. If they can show that it's a COVID related, you have to probably wait sometime during that repayment plan, because some of the ordinances say that you can't evict until after the repayment plan. The question is then, what if they don't just pay their normal rent? And it's not just the back due rent. That's to be seen. We don't know yet. But at the end of the day, the landlords really can't do anything right now. Is there a lobbying group that we can join that will support landlords' interests? Yes, there are a couple. I am an affiliate of the Apartment Association of the Greater Los Angeles. You can go to that website. They're always urging people to go to these board supervisors meetings to try to make sure that landlords' rights are protected. I'm sure there is something on the Apartment Association of California. Yes, my understanding is I get news alerts and they're always saying, this is when the meeting is, sign this petition, do this. So yes, there are those. Can you confirm is now the safer at home order expiration? You mentioned not to expect May rent due to people should be able to return to work on May 1st. Okay, so I was reading the one ordinance from the state. In general, I think that the state order, and it might be the county, I can't remember which one it is supposed to expire on April 19th. So I've been trying to follow to see when, because that's not going to be the case, that's obvious. And I read Governor Newsom an article yesterday that says that it will be extended, but he doesn't know yet and hasn't put a date on it. The guess is it's going to be mid to late May. The moratoriums, those are specifically saying May 31st. There are some that say at the expiration of the emergency order, but those are separate from, I think, the safe at home. I'm kind of just telling people that May 31st is probably going to be the date that everything is going to fall to, that we hope, because April 19th, they're not going to lift that. Like right now, the courts are supposed to reopen on the 20th. My guess is that's not going to happen either. I'd be surprised if they would. So it's just hard to say right now what the expiration will be because it's a moving target. Every single one of the ordinance says that it can be extended. Just to be clear, the tenant has 90 days to pay rent after the state emergency is lifted. No, the ordinances vary from 6 months to 12 months. The courts were not taking any new evictions. So say that you had an eviction that's not COVID related, that it's somebody that is staying after expiration of the lease, or they have violated some covenant of the breach of the lease, or they didn't pay rent in January and February, or something that's commercial related that doesn't have to do with COVID, or they're not protected under one of the ordinances, those can't even go forward right now. Everything has to wait until 90 days after the state of emergency is lifted. If you had a case pending as of the other day, they're all stopped. You're not going to have a trial on any of those cases until 60 to 90 days after, depending on where the case was when they put a stop to it. The repayment plans right now vary from 6 months to 12 months, depending on the jurisdiction. Tuesday, it just might be a blanket 12 months if they pass the motion that they're pending on Tuesday by the Board of Supervisors. So I would anticipate it to be 12 months as the repayment plan. I will share the website details when we get off of, after all these questions and before we close it out. So judicial foreclosures are the same as with the evictions. Judicial foreclosures are halted. Under deeds of trust, that's going to be lender specific. I don't know if the federal government, there might be some regulations that Fannie Mae and Freddie Mac did for those types of loans. I'm just not familiar because I didn't look into it. So non-judicial foreclosures, I think it's going to depend. Can you offer to the tenant a 6-month repayment plan if they agree? Certainly. And right now, if they can repay it in 6 months, sure, but I think that the standard is the way to try to work out a repayment plan is that it's going to be 12 months because there's no obligation whatsoever for the tenant to enter into a repayment plan. The full amount is just due by the end of that repayment period. Does the tenant's ability to pay, does tenant ability to pay only have to do with the reduction of income? If they have savings or collect stimulus grants, can landlords ask them to use those funds to pay back rent? I think that's going to be a case-by-case basis. People out there, even the tenants councils, are urging people that can pay the rent to pay the rent. But people are going to have to triage their bills. If they have something that has to be paid, or they have to use that money to put food on the table, they're going to do that before they pay the rent. A landlord can't make them give up necessities just because they're getting a stimulus check or have savings. You don't know people's circumstances, so my answer to that is no. Landlords can't ask them to do that. There's nothing that says that, but as a good person, I would say that I wouldn't do that. You just don't know their circumstances. Maybe they have medical needs or whatever it is that they have to use that money for. It's all really going to depend on a case by case basis of who, what their circumstances are and how they're prioritizing what bills to pay and what bills not to pay. Is there any other questions? What about tenants on Social Security and elderly? So I kind of touched on that. They should pay their rent. They don't show, there's no reduction of any benefit that they should pay the rent. So if they don't pay the rent, it's not COVID related. So as soon as the courts have lifted their halt on evictions, you should be able to proceed without difficulty, because they're not going to be able to assert an affirmative defense that they couldn't pay the rent because of COVID. But right now, it doesn't matter if they don't pay the rent, because you can't do anything about it anyway. So if they don't pay it, they don't pay it. You're just going to hope that they do. Would you recommend getting tenant approval to use their security deposit to pay May rent if necessary? That's a good question. The apartment association's letter to tenants basically specifically says that you can't use the security deposit for that. I don't know if they're just saying that in the letter to make it so that they have to pay their rent, or because there's no ordinance or anything that says that. The thing about doing that is then you just don't have a security deposit at the end if they damage the property, because they're most likely never going to be able to replenish it probably. So I would just tack it. I would just probably leave the security deposit unless the owner really needed it to pay some bills. What if someone lives in your home and won't pay rent or sign a rental agreement or any repayment plan? So you're renting like a room out to somebody and you don't have a rental agreement already and they just stop paying rent. I think it's going to fall within all these because it's still a landlord-tenant relationship. You don't always have to have a written rental agreement. A lot of people don't and have verbal ones. If they paid rent at some point in time, that already creates the landlord-tenant relationship. So these are all going to apply. Regarding the person that lives in your home, can you ask them to leave? I think that's going to go back to no, because it's going to fall under the landlord-tenant unless that person was never paying rent or whatever the arrangement is. I think that they're going to try to get relief under this if they can try to prove a landlord-tenant relationship. Does that answer your question, Kenny or Frank? Okay. Any other questions? Well, that's all I have. It's a moving target every day. There's changes. Like I said, this as of today is accurate. Maybe Tuesday that's going to change. Maybe Wednesday more changes. I think there has to be some refining to some of these, like the issue I said that when all of this is lifted, even though they have 12 months to pay the back rent, they still have to pay the current rent. So what happens if they're not paying the current rent? Does that landlord still have to wait for the repayment plan? I'm going to say no, that they should be able to do that, but there's not any guidance on that. So hopefully over this next couple of weeks as they refine these, CAR does have some forms, but they said yesterday on the call that not to use them yet because of what happened with Judicial Council. Maybe it was 2 days ago, with the courts changing, that they're probably going to tweak those forms. The Apartment Association does have forms for free if landlords want them. If you follow me on Facebook, I put links to those forms on there today. If you go to the Apartment Association, it's got forms that are crossed out, so you just want to make sure that by the time you use them, you go back and check to see if they're valid, but there hasn't been any changes. And Robert has said that the Apartment Association has a landlord petition that we all need to sign that says the government should pay the tenant rent with a government voucher. So yeah, that goes to the property rights question earlier. Is this legal? Is this fair? You know, I think that that's going to come into play a lot because they're really prohibiting what a landlord can do, but they're trying to do it to protect public health and safety. How about tenants in San Pedro and Lomita? Well, some parts of San Pedro I know are rent stabilization ordinance. So with that, you have to follow the rent stabilization ordinance rules, which are 12 months and no rent increases. Lomita, I don't think is anything but in the county. So the county rules would apply, or the state rules would apply. Okay, so I think that that's all of the questions. Anybody else? So let me, I'll pull up, if you give me a minute, the apartment association. The page that I've been going to is aoausa.com, and they have 4 or 5 links to things on it to get information on resources for landlords, the forms, and the breakdown of, can anybody, I'm not sure because I haven't done where I've taken that off of the PowerPoint. Can everybody see the web page?
No, we still see the PowerPoint.
Oh, okay. Yeah, so landlords are basically screwed. Yes, yeah. But I thought that anyway with the 1482. My Facebook page is, you can just search Kendall Law. I think it's Kendall Law 73 or it's Kendall Law. Or I think maybe even just going to the South Bay Association of Realtors has my information because I'm an affiliate, so you should be able to find it there too. But again, the website is aoausa.com, and that has all the information. Does the eviction moratorium apply to single family residents? It's everything. There's no exceptions. There's nothing that it makes it, if you have a rental, it's going to apply. I think that's all of the questions. Mickey, okay. Do you have any other questions open?
No, I think that's it. And we will be posting the video on our YouTube channel. And I think somebody did request to see that second slide you made that said County of LA. Something about County of LA.
So the County of LA slide is the unincorporated county. This is the one. So right now, Los Angeles County is governed by the state order, except for the unincorporated part of the county and for the city of Los Angeles. But on Tuesday, my guess is that all of these rules that apply to this unincorporated county are going to apply to the county in a whole. And somebody wants to see the one right before this. So this is a state order. My email address is Eileen, my first name, E-I-L-E-E-N, at Kendall, KENDALLAW.net. So it's Kendall Law with 3 L's.net. If you want a copy of the PowerPoint, go ahead and email me and I can send it over to you. I can PDF it and send it over to you. Like I said, this is changing all of the time. I am available if you shoot me an email or go to my Facebook page. I've been trying to keep updates on my Facebook page. I've also been doing out more blog posts. So if you go to my website, I have a link for VIPs for residential or real estate agents. You would get on my mailing list. And I'm sending out pretty much weekly now with changes and updates to try to keep all of my clients and contacts informed. So those are other ways to get information from me as well. All right, I think that's all I have. I don't see any more questions.